Good evening. My name is Lewis Levinson. I'm offering myself for the Chief Fulton County Magistrate position in Fulton County, which, by the way, this election is, May 22nd is the first ever historic election that the Chief Magistrate of Fulton County will be elected. Judge Kirk was appointed by the governor in 2014. She took office in 2015, but this election is the first time that the voters will ever decide who the Chief Magistrate is. Magistrate Court is the busiest court in the state, the busiest. Literally 50 to 100,000 cases, landlord-tenant, civil cases, garnishment cases, criminal. That's the entry-level court for all the criminal cases that come through and ultimately get to the state or the Superior Court. Warrants are issued there, search warrants, arrest warrants, and the initial determinations are made there in that magistrate court as to whether the case should proceed up to the Superior Court or the state court. I've been a resident of Fulton County since, well, almost 40 years. Went to Emory Law School, graduated in 1978. What's my math?
You got 10 seconds, close your fine, right?
And the important part that I want to emphasize, which I should have led with this instead, I was a magistrate in Fulton County for 30 years. I sat on the bench hearing hundreds of thousands of cases, literally. I'll explain that to you if you wish later. And resigned in 2015 and now offer myself for the election.
Thank you.
Good evening. Thank you all for having me. Thank you for allowing us to be here, and thank you all for coming. My name is Cassandra Kirk. I am the Chief Magistrate Judge in Fulton County. I offer myself, and I asked you to keep Kirk on May 22nd, 2018. I'm running for this position because I am committed to using my experience, my platform, and my partnerships to move Fulton County Magistrate Court in the path of progress. My experience includes service as a prosecutor, as a defense attorney, as a civil litigator, as an administrative director, and as a full-time judge on both the Fulton County Magistrate Court and the Fulton County Juvenile Court. While serving as a Fulton County Juvenile Court, it's important to note that I wasn't just simply on the bench, I was also the judge that started the first juvenile drug court program in Fulton County. And so my passion is to protect and serve Fulton County families. That's what I have been doing for over 25 years, and that's what I intend to continue to do. Thank you.
Thank you. Thank you both. People call Magistrate Court the People's Court. You have the most interaction with citizens in the county than any other court. And you have to be very sensible, very knowledgeable. You deal with some complex legal and civil issues. What's in your background that would best qualify you more so than your opponent for this position? I would go to Mr. Levinson on that one.
Well, the fact that I literally sat on the bench every week for over 30 years, starting in 1984. The Magistrate Court was only created in 1983, and I was appointed early on in the tenure of the court and heard all those cases, civil cases, criminal cases, landlord-tenant cases, and the criminal cases as well. And there is no substitute for experience. Admittedly, Judge Kirk has been on the bench for 3 years. I don't know that she has presided over that many cases, but she couldn't have possibly because she hasn't been there for 30 years. That's not to say that there's anything wrong with that, but if there is a question of experience in all the divisions of the court, then I would say that I'm qualified. I hate to say I'm more qualified than anybody else. Was that a minute and a half again?
1 minute for these.
That's
10 seconds to wrap up. You're fine.
In addition to being on the bench, I've been a litigator in both civil and criminal cases for over 40 years. Meaning I've been in the courtrooms of this state and this county doing civil and criminal work for a long time, and that's part of the qualification that comes and brings experience to the bench.
Thank you. And second question.
And thank you for that question, because part of being chief magistrate judge is not about whether you can try a case or not. Part of that is about whether or not you can administer the day-to-day business of this court. As the chief magistrate, you are the person responsible for the appointment of 30 judges. You are the person responsible for the training of those 30 judges. It is my philosophy that the judges ought to be respectful, that they ought to be trained in every area that the court handles, and that is what I have done in this period of time. And so, while I have not been on the bench every single day, I sit 2 days a week. The other thing that I have done is I've paid the court's bills. I've updated, actually I created the court's website. So the first magistrate court website, that was what I did. It took my weekends, it took my nights. So it's more than just figuring out how to sit on the bench. I am NETA trial certified, teacher trained in those skills. I am also child welfare law certified. I've taken particular courses as it relates to procurement and how procurement should move forward. So I am uniquely qualified in various different tasks to serve as the chief judge.
Thank you. Let's talk about the current judicial philosophy that you both share, okay? And I see you smiling because you're just ready to answer this question. A magistrate court judge has a lot of administrative responsibility, okay? And some of that obviously plays into the role as an individual who will decide a case, will decide cases referencing civil primarily. What is your judicial philosophy when it comes to disputes between two citizens? Disputes come before your courtroom. And I'll start with you, Judge Kirk.
May I stay seated?
Yes, you can.
And so the magistrate court is heavily a self-represented litigant court. What that means is we try to do our best to help litigants reach their decision. Because what you are told at the beginning of every civil case is that we have mediators available, please use them. I want to point out that during my tenure, I have made sure that mediators were available in both the North and South Annex. Previously, they were only available downtown. What that does is allow citizens to make their decisions, because as you all know, it's better for you all to reach conclusion than for a judge to reach the conclusion for you.
Okay, thank you.
Well, in furtherance of what Judge Kirk said, the mediation system that was put into place in the early 90s was put in my court. That's where it began, because we were able to institute it by getting AVLF and other organizations to provide the funding for mediators in that court. But about judicial philosophy, having heard lots of cases, it isn't important, it's just as important for the people who come into the court to leave feeling that they've been treated right, regardless of the outcome. Because, you know, if the decision is one or the other, somebody is going to be unhappy with the judge's decision. Unlike the state and superior court, which has jury trials, magistrate court does not have jury trials. So it's all the judge. And so it's equally important that people leave there feeling, if they lost, that they were treated fairly and they came away with the sense that they were able to receive justice, even as a loser.
Thank you.
Mr. Ritchie, if I could make one correction. And so the mediation services that Mr. Levinson is referring to were those for particularly landlord-tenant. The mediation services have been expanded to include small claims civil, as well as our warrant application calendars.
Mr. Levinson, did you want to respond to that? Okay.
She's right.
Okay. Let's talk about community involvement. To what level are you currently involved in community endeavors outside of your legal profession? And Judge, I'll start with you on this one.
I believe that before you can judge the citizens in your community, you must serve your community. I come from a family of service. I am a member of the sorority, Alpha Kappa Alpha Sorority Incorporated. I have been a member since 1994. In that position, I have served various roles. I am also a member of the League of Women Voters of Atlanta, Fulton County, where I have been co-chair for various forums such as this one. I also serve on the boards of the Street Grace, which is aimed at domestic minor sex trafficking, as well as Star C, which is aimed at stability and housing. you will see that what I do inside my community reflects who it is I am and my decision to protect the citizens of Fulton County.
Okay, thank you.
Some years ago, 1980 to be exact, I was appointed by the probate judge to be the county guardian and the county administrator. What that means is that there are people who are incapacitated, adults, and there are estates for which no one has come forward to administer those estates. That work is done on a pro bono basis because there are no funds to pay people to do that. That has evolved into my service with a number of organizations with respect to the dementia, the growing dilemma of dementia in the United States. If I had more than a minute and a half, I'd be able to tell you the statistics about how many people suffer with dementia and it goes unnoticed and are treated improperly by the medical community and the legal community, but I don't have the time.
Let's talk about usability of the courtroom. I've received phone calls on my show. People have dealt with magistrate court years past. To them, they said it was tough to navigate. What are the protocols in place for the citizen? Because as you said, primarily citizens represent themselves in this court. So what are the protocols in place to streamline that process and make it easier for them? And if you would like to implement additional protocols to make it easier for them, and Mr. Levinson, I'll start with you.
Well, let me say, when the Supreme Court of Georgia directed the magistrates around the state, by the way, there were 159 magistrate courts in this state, because that's the number of counties. They said that the charge to the magistrate court was, quote, do substantial justice. And that isn't quite the same as the candidates for Superior Court are required to follow the law. The Civil Practice Act, for example, which is a fancy term for rules of civil procedure, it doesn't apply in the magistrate court. So it gives judges, particularly the chief judge of the court, a heck of a lot more discretion to carry out the intention of the law rather than the letter of the law. And that's a huge value when you're dealing with a landlord and a tenant fighting over property, or a civil case, putting aside whether it can be settled outside of court through mediation.
Thank you. Same question, Judge Kirk.
And so in 2017, as court administrator, I applied for and received a grant from the National Center for State Courts. We were one of 4 courts to receive that grant. The purpose of it was to work on a pilot project in order to make our high volume calendar more usable. And what that means is people coming in off the street, how is it that they can feel that they can get justice done? So what we have done is, if you go to our website, you will see that there are videos. There are videos that walk you through what it is that happens in a case. So that's part 1. The second thing we've done is we have implemented pamphlets. And so pamphlets tell you part 1, step 2, step 3. There are pamphlets for our high volume cases. The high volume cases I'm talking about are landlord-tenant cases, our small claims cases, less than $15,000, as well as our garnishment matters. And so those are very tricky matters that the public deals with every day, and we have implemented systems to make that possible. I have one more thing, and that is we have implemented the Housing Assistance Center in order to help navigators as it relates to the landlord-tenant cases.
Okay, thank you. And for this question, I'll start with Judge Levinson. If a person comes to you, they have a dispute, and in this dispute, they may be in the wrong, and the law will say you have to move, you have to get out. As a magistrate judge, are you able to apply compassionate justice to give them more time to move from their property before ruling, even though you know they technically are in violation and should lose the case?
Well, the answer is yes. The law simply requires that you cannot give a tenant who's evicted less than 7 days. That's what the law is. But that does not preclude a judge from taking into account the charge from the Supreme Court, which is do substantial justice, and give that person more time. Or, alternatively, and I know this is revealing a super top secret now, sometimes the best decision by a judge is no decision at that moment. A continuance or a postponement of the case works substantial justice because, in answer to your specific question, though I wouldn't tell this to the litigants, and I ask you please keep my secret, the idea is let the litigants go home and sort of cool off. Sometimes those cases don't come back. That happens about 50% of the time. And sometimes if they do come back, essentially I've achieved what the question suggests, which is granting the tenant more time.
Same question, Judge Kirk.
And so the magistrate's job is to do substantial justice. The magistrate's job is also to follow the law. And at times you make decisions that are uncomfortable, and you have to explain to the tenant, this is what the law requires that I do. But in order to have finality for the tenant, for the landlord, unless the parties agree to something different, the judge should follow the law, no matter how difficult and uncomfortable it is.
Okay. And I'm managing the time, so let's go to our Q&A from the audience. If you have a question, please raise your hand. I will recognize you for your question to this panel. Yes, sir. Dr. Cobble, good to see you.
My question is, while your experience and has dealt with the landlord-tenant, what can you tell us, especially in dealing with people of color? Tell us about the foreclosure where individuals may have, whereas processes of illegal and fraudulent processes has been done on individuals' property, but yet they come before your bench to remove them from their property. What can you tell us, especially with people of color, that you will render justice to be sure that they won't leave your court that feeling that they was able to get something done on their behalf?
I assume your question is directed at me. The answer is Georgia was one of the highest volume of residential foreclosures in this state. It was also one of the highest volume of fraudulent foreclosures in this state, excuse me, in this nation. If I said state, I meant nation. Apologize. And the answer to your question is a little bit technical, but I'll try to parse through it, sir. In order for someone, a lender, for example, that's foreclosed on a piece of property, or an investor to foreclose and evict, there are a multitude of procedural prerequisites that have to be followed. And I will tell you that 95% of those who foreclosed did not know what those procedures and those prerequisites were. So the result is, and frankly, most of the people who were the defendants were people of color. And so, though that wasn't a factor in my mind, here's a set of rules that says this is what you got to do to foreclose on a piece of property and then to evict someone following a foreclosure. And the result was that a lot of those cases got dismissed. On the other hand, there were a lot of opportunists out there who took advantage of this when there were a lot of vacant homes in all the communities around Fulton County. People just move into somebody's house. Now, if that was next to your house where they moved into it, guess what happened? That house, nobody took care of it because it was being occupied by essentially interlopers or, vagrants. And it ran down the values of the houses in the neighborhood, causing the crisis of devaluation of all the real estate in the county to suffer. So it isn't quite as simple as, it's not a simple analysis. There's a lot of community factors that go into keeping everyone, those who live alongside of those properties and those who are being victimized, in being treated fairly. I want to say one other thing about I've always, in my private practice, which has continued since 1978, I've always fashioned myself something of fighting City Hall. Literally fought City Hall, for example, literally, Atlanta City Hall. When the Olympic vending case began, you may remember that the Atlanta Committee for the Olympics, through then Mayor Bill Campbell, sold permits or licenses to folks who were almost 100% minorities from around the United States. They were all ripped off. I fought City Hall as their lawyer for 10 years. 10 years in the courts until the case settled after Mayor Franklin became the mayor and saw fit to settle the case. So it wouldn't be correct to say because I'm a middle-aged white male, I'm ignorant of the issues that affect everyone.
All right, thank you. Did you want to answer that as well?
I'm unsure it was directed to me, but I can tell you that I come from two parents from Mississippi who look just like me. I have been black my whole life. It is it's something that I take to my bench, those experiences, in places where I maybe should not have been, those experiences, as well as places where I was welcome. And so I understand what it's like to come into a building to be confused. And so anyone will tell you that has seen me in juvenile court, that the first thing I did was level the playing field, make sure that each of the sides understood what was happening. The same thing in magistrate court. There is an opening statement that happens so that everyone can understand what's going to happen today.
Thank you. Any other questions from the audience? Yes.
I still really don't understand. I mean, his question it wasn't really answered because about 65% of black people do lose their homes, and a lot of people that are homeless have lost their homes. And by the time Wells Fargo or a lot of these mortgage companies do their robo-sign and all their fraudulent illegal acts, we don't even have the power to do anything. It's already done. So we, as African Americans and even poor white people, we don't get the same level of legal advice and legal help. And as you said this morning on your show, even black people do each other wrong. So it's not just per se a white man or a black person per se. It could be any person, but it's always the majority of African Americans
So may I
and
respond?
poor white.
Sure. I'll let you
So-
both respond to it.
What I will tell you is that that is the reason that the navigators are in the magistrate court now. So in the clerk's office in TG 100, there is a housing assistance center. Those are people that will help you navigate what's going on in the system. They will help you figure out if in fact you need assistance further from Atlanta volunteer lawyers. And it's because people come in. Landlord-tenant cases are fast-moving cases. You are absolutely correct. But in order to level the playing field, because as a pro se litigant, as a self-represented litigant, you don't know all the same rules that the lawyers know on the other side. And so that was one way of leveling the playing field, because I am conscious of that. I'm aware of that.
Thank you. Judge Levinson.
What I think you're asking is, how do we balance the fact that, and there's no denying that the vast majority of people who are tenants in Fulton County are African American. The vast majority of the tenants who come into the court in Fulton County as tenants are African American. If someone complains about being wrongfully foreclosed upon, is that your question, ma'am?
Well, it's just that there's a higher level of African Americans that are unlawfully and illegally foreclosed upon, and I've actually met with my mortgage holders, and you got people like Wells Fargo. They do fraudulent stuff all the time, and it's very well known. It's not just them. Okay.
Let me
And she's
answer-
talking about market manipulation.
Yes, let me answer this, and let me
Unlawful
say
home foreclosure.
that Superior Court Judge Willis or Farmer or Wolf would have to be the ones to decide the issue of title. And let me explain why. The legislature does not give to the magistrate court the ability, we call it jurisdiction, to decide title. So let's say you were claiming that you had been the victim of a fraudulent loan and then were foreclosed upon improperly, which by the way happens all the time. Even if I wanted to, I could not undo that foreclosure. But what I can do, and what I did do for 30 years, is I would say, I'm going to reset this case so you can get a lawyer and go to Superior Court, one of the just using the example of the persons who are running for Superior Court, go before one of those 3 judges and get an injunction against the mortgage company to evict you in my court. Then they show up with a piece of paper that's got one of their signatures on it. That ends my case, because the magistrate court in the food chain is the lowest court, and there are higher courts, and there's no higher court in our state than the superior courts of our state. So the answer is, if I suspected, if I had a hint or a scent that there was something wrong with it, there are ways, without deciding what I can't decide, to give that person the ability and the time to get what they need in another court, which does have subject matter jurisdiction. I didn't write these rules, and to some extent, we judges can't create our own set of rules. I understand the frustration, because I saw it every day for a long time, but there are ways to protect people who are truly victimized.
Thank you.
Thank you.
And we are running flat out of time. I have enough opportunity here for a closing statement from both candidates and Judge Levinson. I'll start with you. And for those who are wondering why I'm calling him judge, he's a former judge. Anyone who's a former judge, I would retain that title in debate formats, okay?
Thank you very much. The magistrate court is different from most courts. I'll give you an example. If I were elected, I would have an open door policy, which is to say, if any member of the general public has got a grievance, not with the way a specific case was decided, because that would be improper. You got a grievance with the way the system is operating, you come see me. My cell phone number will be published in the, whatever the website is for the magistrate court. Now, a lot of people, when I was on the bench, would call me up and say, Judge, I didn't like the decision you made yesterday, and I have to hang up that phone. But if somebody calls me up and says, I think that the clerk's office isn't doing what they're supposed to do, or I think that there's a faster and better way of achieving case management or court management, then what I would do, and I did this when I was on the bench, convened a meeting with lawyers for the plaintiffs, lawyers for the defendants, members of the community that are both pro se and businesses, and I said, come on, let's sit down and have a talk about it. We learn a lot of stuff that we don't know because there are so many judges in the magistrate court. Each of them is sort of touching the elephant at one point, and they're not seeing the whole elephant from a 20 or 30 foot distance. And I do think that is doing substantial justice. I also want to say that I don't think there really is any substitute for experience as a courtroom person. I think having served as judge all those years and having retired when Governor Deal appointed Judge Kirk gave me the perspective that there was a need to come back and correct some things. Tonight's not the night to talk about those specifics, but I believe that there are ways of saving the county hundreds of thousands of dollars and making the court system more efficient. And I'd like to be able to do that if I'm elected.
Thank you.
My name is Cassandra Kirk. I am the Chief Magistrate Judge in Fulton County. For the past 3 years, I have served this court. For the past 3 years, I have brought innovation to this court to ensure that it is efficient and that it is accessible. I will continue to do so. Some of the highlights of what I have done during my services, we have closed 30,000 small claims cases that were backlog cases, closed in 2 years. Those cases have been open from 2010 to 2015. One of the other things that we have done is we have appointed judges in an open process. And you've heard today that whomever wins this seat will appoint 30 judges. Why is that important? Because when people are asking about civil justice, when people are asking about criminal justice, it's important for the community to be represented. I will tell you that of the state court bench, 5 of those 10 judges had been magistrates. Of the superior court bench, 6 of those 20 judges had been magistrates. The magistrate court could be a training ground for those people that wish to step to the next level. The other thing I want to tell you is that I have increased the efficiency of the court. I have increased the usability of the court. I'm asking for your support in asking that you keep Kirk on April 30th and May 22nd, 2018.
Thank you. Thank you both. Let's give both of these candidates a round of applause.